Greetings. Today we are looking at the subject of objectivity and subjectivity at in adjudication in law, one would say. So we have these two terms here: objectivity and subjectivity. So what we are basically saying is that whenever a court is adjudicating, whenever a court is faced with a case, it applies itself to the facts, to the law, and to the legal questions in order to reach a verdict. So, and we are saying that its decision is shaped by one of the two approaches. There is an objective approach and there's a subjective approach. So, without further ado, let's look at how these two get to be defined. So talking then about key issues, we are trying to answer questions to say, what is the distinction between Yes, we are looking at the difference between objective approach and the subjective approach in adjudication of cases. And what we are looking at is a definition of the key issues, rather drawing a distinction between what we mean by an objective approach and what we mean by a subjective approach. So we are saying, we are trying to answer the question, what is the distinction between the subjective approach and the objective approach in the interpretation of law? Subjectivity occurs when an opinion or a conclusion is based on facts separate from the person making the conclusion. So when you decide based on facts or factors that are outside of yourself. For instance, when you look at the rules of law and you are applying rules of law, we say that those, facts or principles of law or the rules of law are not part of you, they are outside of you. So when you apply those rules of law, you are undertaking an objective process of adjudication. So your conclusion is going to be based on facts that are separate from yourself. And so a judge who makes use of, facts outside of himself is said to be applying objective law. So when it comes to theories such as legal positivism, as espoused by the likes of H.A.L. Hart and people like Jeremy Bentham and people like John Austin, who apply what they call the positive law. So the rules of law, therefore, offer an objective, a yardstick against which the decision can be made. So in other words, when you look at a decision, you always ask yourself a question: can it be measured against an external kind of a standard? Now, it's different from subjective. When we talk about subjective adjudication, because then we are saying it occurs when a view or opinion depends on the perceptions or principles of the observer. So when the perceptions and the principles of the observer are taken into account in adjudication, then under such circumstances, we come to say we are making use of subjective and as a subjective approach. For instance, when you talk about the issue of morals, when you apply issues like such as values, such as morals, you know that our moral attitudes differ from one person to another. So if a judge is going to be applying morals, as is often the case in the case of natural law thinking, those who base their adjudication process on natural law, the likes of Aristotle and those who follow the Aristotelian approach, or Plato, or the likes of Thomas Aquinas, the likes of yeah, modern, naturalists who apply what is called metaphysical factors. They are metaphysical because they are beyond what the physical can fathom. And we are talking here about your morals, moral values, your value system as a human being. So that tends to be subjective because it depends on the perceptions or principles of a particular observer. And as we have said, things like morality are subject to your cultural background, your cultural upbringing, even your personal disposition, because human beings always get disposed differently. So subjectivity, therefore, will take into account your previous experience. For instance, an adjudicator who applies a subjective approach could then begin to bring in his or her own experiences, issues like their racial prejudice, ethnic prejudice. If, for instance, you happen to be a magistrate or a judge as a woman who has suffered sexual harassment or sexual abuse at the hands of a man, and another man comes and stands before you being accused of sexual assault, do you bring in your own personal experiences into the adjudication process? Do you look at the accused before you on the basis of what you've experienced as an individual? That would be very subjective, because then it means you are bringing in your own personal prejudices, your own personal value judgments, and your own personal, feelings about the whole thing. And the question that stands before us is, should judges make subjective or objective rulings and legal interpretation? That's a question that you will ask and answer. I've got my own answer. Maybe as we proceed, you will find out what my answer is. And so, talking about subjectivity, maybe before we even look at this, so far we have said that objectivity is applied by way of ensuring that the decision is based on, factors or facts that are separate from the person. They can be viewed on their own, they can be assessed on their own. So the judgment or the decision can actually be assessed and evaluated against the criteria that are external to the person making the decision. So coming then to the issue of subjectivity, we say that there are basically two different, in fact, they are not two, they are more than two. This title here will have to be changed. Instead of saying there are two, they are, let me just say different, because they are more than two. Different forms of subjectivity. There is subjectivity where a judge neglects relevant material. For instance, if a judge to neglect relevant evidence, statutes, or case law. In other words, a lawyer is arguing a case and brings the evidence, the statutes and case law, and the judge refuses to apply that kind of that evidence or that law before him or her, then that is a form of subjectivity where relevant material is ignored and left out completely. And there is subjectivity where the judge inadvertently or unintentionally exercises discretion harshly or leniently due to personal circumstances such as sympathy, resentment, fatigue, hunger, or irritation. I gave the example of a magistrate or a judge who, as a presiding officer, has before him or her a case involving sexual assault. and he has also suffered sexual assault in the past. So he then factors in his or her own experience in the whole matter. You see that kind of thing, or you have a judge who suffered a divorce at some point, and then when a matter is being brought regarding divorce, he now brings in his own or her own experience and her own prejudices. That would be very subjective. So that is exercising discretion harshly or leniently. When somebody considers his own personal circumstances and maybe becomes sympathetic towards a certain litigant or resents another litigant, maybe based on racial differences, based on ethnicity, or based on nationality, or any of the grounds that may cause one person to discriminate against another. So that would be a second form of subjectivity. Then thirdly, we have subjectivity where a judge yields to pressure from third parties to make a biased decision, based maybe on discrimination against certain groups of people, or having received a brown envelope. That would still be a kind of subjectivity. And then subjectivity where a judge interprets the law according to his or her own set of moral or political principles. So you can imagine during the apartheid era, judges who would also, decide cases based on what they thought about racial relations. So in other words, they become players instead of being neutral adjudicators. So when the judge interprets law according to his or her own moral or political principles, that is a form of subjectivity. Then the subjectivity, we are saying subjectivity can be deemed as extreme or as moderate. So the next step of our discussion is to look at the distinction between extreme subjectivity and moderate subjectivity. Now, considering extreme subjectivism or subjectivity, we have proponents who argue that legal interpretation cannot be objective. In other words, there are people who are saying whatever decision or interpretation of the law a court makes is never objective, but there's always the influence of the personal circumstances, personal experiences, and personal prejudices of the adjudicating officer. So they are saying that extreme subjectivism is represented by two streams, where we have legal realism as well as postmodernism, that is. So the leading scholars of legal realism are Oliver Wendell Holmes Jr., John Chipman Gray, and Jerome Frank, as well as Carl Llewellyn. These ones argue, they look at the judges, they look at how judges make decisions and relate this to society. And so what do they say? They say that the legislature provides the source or the occasion for the law. But when the courts apply the law, they are actually creating a new law. So that would be consistent in a way with the theory of legal activism, whereby they are saying that the law as you have it in the statute or in the constitution is because it's not being applied to concrete situations. It is not really capable of solving problems. It is just a source. It is just a foundation. But when the judge goes ahead now to apply the law to the particular situation, the concrete scenario, then that judge is the one who's making the law. So that would also be consistent with this principle of stare decisis, that is the issue of binding precedent. For instance, why do later courts always have to be bound by the decisions of the earlier courts, whilst the earlier court was making an interpretation of a certain statute or a certain law. It is simply because the later courts are accepting that the creative work of the previous court, which created a law out of the statute, was in a way correct. It applied the principles correctly. So judges make decisions. In fact, they make unpredictable decisions based on emotions. So we are saying that the issue of emotions do come in, and these judges apply their own emotions rather than being rational. So they don't apply a rational system of rules, but they apply their own emotions, their own, factors that are external to what do you call the law that is before them. So that's what the realists do. And then, so the realists, as I have said, they are one leg of extreme subjectivism, and the other leg is provided by, maybe before we even go, the other one is provided by postmodernism. So what do we mean here when we look at postmodernism? We are saying that sometime in the late 20th century, a movement called postmodernism emerged. It was characterized by value skepticism and subjectivism in a way that where they are very suspicious of reason. So, in other words, the postmodernists are very skeptical in their approach. They are skeptical. They don't believe really in the validity of reason. And they also do not believe, they are very suspicious of reason in a way. So skepticism is the main characteristic of postmodernism. They argue that interpretation of the law is based on one's own values, which lead to a subjective judgment. So every judgment is a subjective enterprise. One's own value system influences the judgment that one eventually issues. In other words, when you are an accused or a litigant before a court, the outcome of your case actually depends on the subjective values of the presiding officer. So postmodernists are often identified with French philosophers. They accept that legislators do make law through the judge's subjective, though the judge's subjective interpretation clarifies that law, something which realists do not. So according to the postmodernist, the legislator makes the law. And then it is the subjective decision coming from the judge which finalizes the matter. But realists, on the other hand, as we have seen, what did they say? We can go back to them. They said that the courts are the ones which make the law. So the postmodernists say that the legislature makes the law. Now, postmodernists place a high premium on values by observing that it is possible for human reasoning to understand values as objective in some way. So as far as postmodernists are concerned, values can actually be a very useful tool. And they accept that values can be captured in principle and theory. Now, look at this. How many people do we have, and are their values or value systems the same? As we have said, a person's value system is influenced by their family background, cultural background, historical background, experience, the exposure that they have had, and so on and so forth. So how do you capture all these varied, what you call, these varied values into a legal system? So postmodernists hold on to value skepticism. They are also skeptical of value. I think we've mentioned that, which states that certain accepted values are only true for some people. So the issue of particularism, certain values are true for some people and not for others. And they contend also that values are contextual in nature. So even your own personal values would, they vary from your circumstances at some point, and then at another point they will be different. And in the South African context, one of the leading scholars is Patrick Lender, who argues for value skepticism and contends that a legal system cannot be rationally supported or justified by good reasons. So Lender says that reasons are not sufficient to justify a legal decision, because whenever we exercise reason, we are in a way importing our own subjective views into the whole exercise of reasoning and passing judgment as judges or magistrates. So we do not discover any claims that are certain. In other words, that's why you find a court, whether it's the constitutional court with the full quorum of, is it 9 or 11 judges, or whatever, a full bench of the High Court with the 3 judges and so on. Each one of them is going to pass a judgment and give reasons. And as you will have agreed with me, as you will have noticed when you read these reasons, that each judge's reasons may be different from those of the other. So at the end of the day, reasons are not something objective or something, scientifically determinable. So because reasons vary from one person to other reasons are subjective in nature, because to reach a reason, it depends on what factors you may have looked at and what weight you've attached to one factor or one piece of evidence as compared to the other. So the issue of beliefs comes in, and the question is, who told you that your own moral beliefs are true? For that judge who sits and convicts or passes a judgment in favor of one litigant against the other, who is applying his or her own moral beliefs, who told him that his or her own moral beliefs are actually true and objective? So in a way, there's always an element of subjectivity. And Dawkins notes that there are widespread differences of opinion about right and wrong. So that's Ronald Dawkins. Ronald Dawkins, of course, distinguishes between hard cases and simple cases. And then he says there is no objective effect. In fact, he says that there are widespread differences of opinion about right and wrong, that there's no objective effect proving the matter. So when two people are faced with the question of what is right and what is wrong, at the end of the day, whose decision should carry the day? How do you distinguish between one person's logic and that of the other? So that's as far as postmodernism is concerned. And then, so we have spoken about what we called, we started off here when we said that subjectivism can be viewed as extreme or moderate. And we have spoken about extreme subjectivism when we were looking at the views of the realists as well as the views of the postmodernists. Now I want us to look at the views of, in fact, we want to look at moderate subjectivism, where we are saying we have 3 major theories when it comes to moderate subjectivism. We have what we call the critical legal studies, the CLS, and then we have critical race theory, and then we have feminist legal theory, or FLT, which some people prefer to call the critical gender theory. That is the CGT. So, what do we mean here when we look at these three? We are going to look at the three of them, starting with the critical legal studies. Critical legal studies, of course, as we are saying, it represents a form of moderate subjectivism. And we are saying it emerged in the United States in the 1970s, and it grew from the earliest movement. And it actually espouses the view that the law is whatever the judge decides. So, to a moderate view, the judge interprets the law in any way that he or she sees fit. So, judicial interpretation is actually a product of extra legal factors. So, in other words, a judge that comes into a case always comes in with his or her own views, because a judge is not a machine. It's not like a coffee machine, coffee maker, whereby the amount of coffee you put in determines the taste of the coffee, whether it's going to be black coffee or light coffee or whatever. A judge is a human being who comes in with his own prejudices. So these extra legal factors influence the outcome of the decision, the judicial decision. And he's saying political influence is one of those extra legal influences. So depending on one's political persuasion, one's view of the world, they say it is saying that issues should benefit the people of the bottom of the economy. But remember, we have Marxist politicians, and then we have capitalists. So each legal system actually reflects the prevailing political views. As Blitz and others noted in 2017, critical legal studies advocate seeking to undermine supposed neutrality and objectivity of legal practice. So as far as critical legal scholarship is concerned, there is no neutrality, there is no objectivity. So the supporters of this debate actually opine that judges ought to adjudicate in light of the in South African context, the judges must apply principles of subjective constitutionalism as a way of trying to overcome the injustices of apartheid. In Nigeria, we have a scholar called Akinola Akintanyo, a jurist who also holds the view that judicial accountability and citizen participation are essential, because judges need to be transparent about the decisions. They must be explicit about the political values that they hold on to. But the question is, how can this be communicated? For instance, would the judge have to indicate that he is a Marxist, or he is a capitalist, or he is a whatever ist? You see, that kind of thing. But according to this view of critical legal studies, the judges must actually provide their reasons, and they provide their political background, whatever factors are influencing them. And then, having looked at critical legal studies, we now look at the critical race theory. Again, this one developed from the United States of America in the early 1970s, pioneered by Derek Bell, who was an Afro-American, as well as Alan Freeman, who was a white American. There was also Patricia Williams, an African-American woman, and it developed well into the 1990s. Now, they were concerned about the slow pace of racial reform in the United States of America. In terms of critical race theory, judges are influenced by extra-legal factors related to political and moral views. And they are saying that racism plays a very important fact there. For instance, whenever a black suspect is brought before the court, there's been a tendency to convict, whilst the same, I mean, a white person with the same charges and under the same circumstances may escape with a lighter or sentence or even be acquitted. So critical legal scholarship profiles seems to focus on class difference, but according to critical race theory, race is a very important factor. So to only focus on class is to obscure the real issues. So blackness is a factor. In South Africa, Joel Modiri is actually written extensively about this. So Joel Modiri is a critical race theorist, and he has noted recurring themes of critical race theory through the anti-black racism. Remember the racism that led to the killing of people like Steve Biko. And he says there's been impatience and incremental change, and there's greater sympathy towards normative category of right associated with critical legal scholarship. So he says that the legal system is not colorblind. The concept of a colorblind, a race-blind legal institution, especially in the South African context, it does not exist. He says, in a way, the adjudication process must take into account that black people have come from a background of exclusion, whilst white people have come from a background of privilege. So even in looking at the experiences legally, if you are profiling criminals or suspects or you are adjudicating, they should really be taken into consideration that black people come from a background that has always criminalized them and so on. So a discussion on the importance of appointing black judges is imperative in the context of South African law, because the subjectivity of white judges is actually importing white values into the predominantly black communities. So as long as judges continue to be white, then even judgments will tend to reflect that bias towards whiteness. And so the answer to this is to ensure that there should be a balance in appointing judges. There should be, a consideration of race whenever appointing judges, to ensure that you do not overburden the black communities with the value systems of the whites, because those value systems tend to be reflected in the judgments all the time. And then lastly, there's the issue of feminist legal theory, developed again from critical legal studies as well as critical race theory in the 1970s. And it has led to what is known as feminist jurisprudence, which is based on the belief that the law has been fundamentally biased against women. They're saying historically women have been subordinated. Even the law has been designed in such a way that it is, biased in favor of men, in favor of masculinity against femininity. There's the pioneers of this field are Priscilla Cornell, Catherine McMillan, Deborah Roddy, and Robin West, John Williams. Most of these are Americans. They address various topics with a prominent focus on identifying the laws and profiling policies the people like Frog have also been at the forefront. So they mentioned that the law is in a way subjective, because in terms of feminist legal theory, there are three contributions that really this law has made, this theory has made. Number one, it questions the foundation about the values and the benefits and the burdens that must be distributed in society, and has invoked the adjudication of disputes. So the other contribution is how to understand terms such as reasonable. What do we mean by reasonable? And then when we say that there is a difference between men and women, what exactly are we saying? Does it relate to the fact that women have a different situation than men? And what is masculine is perceived as normal, or what? So in the case of South Africa, with Karen Nell, who is a South African jurist, also focused on feminist jurisprudence, and Catherine Mackinnon, as I have said, is an American. So instead of focusing on the difference between men and women, it brings then the issue of, it always raises questions to say, are men and women fundamentally different? And if they are different, what does it mean about how the law should approach them? So those are some of the things, especially to do with the critical feminine, critical gender theory. I want us to look at a case, a legal case that was heard in the South African courts. I'm trying to move my stuff here. Right. The case of the President of the Republic of South Africa versus the the President of the Republic of South Africa and the Minister of Correctional Services versus John Philip Peter Hugo. On 12th of November 1996, and the matter was heard by the Constitutional Court. This case involved a kind of an amnesty that the President of the Republic of South Africa had given to mothers who were serving jail sentences, jail terms. So mothers who had children below the age of 12 were then released on certain conditions. And then there was a man, Peter Hugo, who also happened to be a father who had a child who was below the age of 12. And Peter Hugo also happened to, in fact, he was serving a jail term, but because he was a man, he did not benefit from that amnesty that was given to mothers. So he took the matter up for challenge with the Constitutional Court and argued that the law that the president had used, in terms of which he had caused a release of women from incarceration and from serving their prison sentences, was actually discriminatory against him, as well as against his own child, because he said that his own child was deprived of a parent who remained in police, or rather in prison, just because his own parent was a man and not a woman. So the issue of discrimination between men and between women in terms of granting what you call an amnesty was in a way biased in favor of women and against men, in favor of children whose parents were women being taken care of by women, against those children whose parents or happened only to be men. That is the men that were parents that were taking care of the children. So in terms of feminine legal scholarship, one would say if men and women are the same, why did the president, for instance, give an amnesty to women but not to men? Under what circumstances should we say men and women are the same? Should the law actually pay attention to issues of gender, femininity, and masculinity? When femininity is used in favor of women, for instance, releasing women from prison, is it being discriminatory against men? And at what point should we say that it is fine to treat men and women differently? So the issue then of critical feminine or critical gender theory, or the issue of what we said was feminist legal theory, comes to the forefront here as we try to understand whether it is proper to distinguish between men and women. Because the prevailing argument has always been that men, in fact, they are saying the law is crafted in such a way that it favors men. But when there is time to give amnesty, it becomes proper to release women in terms of an amnesty, but not rather provide the same benefits to men in similar positions. So those are some of the most critical questions. So the president's decision, was it rational? Was it based on emotion and prejudice? Was it prejudiced against men or prejudiced against women? And so on and so forth. So that's what critical legal theory is all about. And we are saying the long and the short of it, whenever the courts have to make a decision on anything, particularly on any matter before them, do they apply the objective facts, the objective law, or they apply subjective facts or subjective law? So on the basis of that, we had asked a question earlier to say, what is my own view? I believe the law should be applied as objectively as possible, but because it is being applied by human beings who are bearers of emotions, bearers of prejudices, bearers of attitudes, bearers of moral beliefs, and so on, in an attempt to be objective, the subjective element always comes in. But in the interest of justice, objectivity is the most preferred approach, though, of course, always difficult to attain. Thank you very much for taking part in this discussion, taking part in this listening right through to the end. I certainly hope that this discussion has shed light on some issues that you probably had questions about. Feel free to contact me on any of the matters. Thank you very much. Have a good time. May God bless you. Bye-bye.